Okay, let's get started. We'll probably have time for some questions at the end. So if anyone does have any questions as we go along, please feel free to put them in the chat function or the Q&A function, and we'll try to pick those up at the end. Thank you for joining us this morning. Hopefully you're all working from home and didn't have to deal with packed trains on these strike days. But we're very grateful for you taking the time out of your morning to join us for this webinar on the Court of Appeal decision in ADP RPO UK Ltd and Haycocks. Kieran and I acted on behalf of the successful employer in this Court of Appeal case in relation to small-scale redundancy consultation. What we will do today is we will talk you through each stage of the process. So what the focus was at the tribunal, what the focus was at the EAT, what the focus was at the Court of Appeal, and then what the Court of Appeal found, and some practical lessons in relation to small-scale redundancies going forwards. So I keep getting a notification, that's why I keep looking down, but I'm not sure what that is. I hope nobody can hear that noise. I hope that's not distracting anybody, but please let us know if it is. So we say small-scale redundancy because, of course, this was not a case where the employer was proposing to dismiss as redundant 20 or more employees, and therefore the collective consultation provisions relating to appointing and consulting with representatives did not apply. Instead, the general principles set out in Williams and Compare Maxim applied in this case. I was instructed all the way from the tribunal hearing and in the EAT, and Kieran joined me as my junior at the Court of Appeal. So I'm going to be addressing you on the facts of the case and the key points of discussion at each level, as I've said. And the reason I think that's important is because it's useful for employers and practitioners to know the particular points that judges focus on in each stage, and points to think about in advance of a redundancy process. And I'll be making some practical suggestions as we go along. Kieran will then be addressing you on the Court of Appeal decision and practical tips for conducting small-scale redundancies on the back of the Court of Appeal decision. Turning then to the facts of the case, this was a standard redundancy situation, standard redundancy process. There was a downturn in work due to COVID. All 16 employees working on the particular contract were placed in the pool for redundancy, and selection criteria were used. Now, the claimant scored the lowest in that scoring matrix. However, all 16 employees in the pool were consulted with. There were 3 individual consultation meetings. There was lack of any real engagement from the claimant, which is often the case, as many of you will have found if you've got experience of redundancy processes. And the claimant was dismissed at the 3rd and final consultation meeting. The claimant's appeal against dismissal was not upheld. So on any view, a very standard redundancy process. The only differences here, and some quite key differences, was that the scoring was carried out before employees were informed of the redundancy situation and before the consultation process commenced. The second point is that the claimant was not provided with his scores until after his dismissal, but he was thankfully given the opportunity to challenge his scores during what the tribunal found to be a conscientious appeal process. Now, in the tribunal, the claimant was represented by his father. There was very much a focus on his side on the evidence that the manager relied upon in reaching the scores. The focus of the claimant was on the what he said was a manager that had essentially set him up for a redundancy because he didn't get on with him. That was very much a red herring, because that particular manager had no involvement in the redundancy process or in the scoring, and it was quite a historic situation which played no role whatsoever. The focus of the employment tribunal judge, however, was on the evidence of the manager who did the scoring process. So the judge wanted to know what objective basis the manager had for the scores that she had given. Now, luckily, we had a manager that was able to answer those questions in cross-examination, but many managers wouldn't be able to do so. And so some practical tips to take from that particular issue is that, firstly, training for managers in redundancy processes are key. We often find that managers are not trained in these processes and therefore are not aware of the types of wording and framing that they need to use in relation to redundancy. Secondly, it would be useful if there is written guidance for managers that are carrying out scoring processes, so they're not just left in the dark as to how to conduct a scoring process, but they have some guidance that they can rely back on and show an objective basis for their scoring. Thirdly, it would be useful to be able to show that the scores are not just numbers in a box. So it'd be useful if the managers record their rationale for the scores given, as opposed to trying to come up with their rationale after the event in a stressful tribunal process. Secondly, it would be useful, if possible, to have a scoring panel or someone to sense check the scores or have a calibration process for scores, so it's not just the decision of a single manager, and it can't be said to be a subjective scoring process. Now, in our case, the manager in question had checked the scoring with her manager, and therefore she could show that there was an additional level of assessment and an objectivity process applied. Now, the judge in that case found that the claimant had not challenged the good faith of the manager that carried out the scoring, and overall, taking account of the appeal process, the redundancy process was fair and reasonable in the circumstances. So far, so good. Some might think that as it was a standard redundancy case, how did it get all the way to the Court of Appeal? Well, that's where the EAT comes in. Now, Mr. Haycocks, with a bee in his bonnet in a good wind, found favour in the EAT. Now, I just want to pause there for a moment and just step away from the Haycocks case to consider some of the recent trends that we've seen in the EAT in relation to redundancy, because there's been a number of cases over the last few years which suggest a pendulum swing towards the EAT clamping down on redundancy processes. Now, these cases are not on the slide, but I think it's useful just to mention a few of them. So, for example, the pool of one. Now, that is a topic that sometimes comes up in redundancy processes, and it used to be the case that if the employer had genuinely applied its mind to the pool, then deference was left to the employer in relation to the decision that they made. We've found, however, in the EAT recently that the EAT are expecting greater consultation in relation to a pool of one. So, for example, in the Mogane case, that's Mogane, the sole selection criteria used in that case was based on the expiry date of a fixed term contract. And the EAT found that consultation should have taken place prior to the decision on the pool, at a time when the employee could still potentially influence the outcome. And the reason they did that is because, of course, the employee had no ability to influence the outcome where the only selection criteria was the end date of a fixed term contract, and therefore the decision was set in stone at the point that sole selection criteria was used. There's also another case called Teixeira, so that's Teixeira, and there's also is a decision in relation to the pool. In that case, no process was followed at all there. So essentially, it was a decision based on Polkey, but the EAT found that it was possible that consultation might have led to a change of the pool or the outcome, and therefore there was a 100% Polkey reduction was not appropriate. And the EAT found at paragraph 21, there is a similar risk where a pool of one is chosen, as it could be used to get rid of an unwanted employee. Accordingly, there is good reason to examine a decision to choose a pool of one employee with worldly wise care. So that shows that greater scrutiny will be applied in cases where there is a pool of one. So if the employer has decided on a pool of one, then it would be prudent for them to consider why they've reached that decision and note their rationale for having done so, but equally to consult the employee in relation to that and take on board what the employee says and consider whether that changes their decision. A further case that we saw that came out the judgment came out just before we, so I've just been asked for the case name. So that case was Teixeira, so it's Teixeira. So the next case that I wanted to mention is Valimulla, so that's Valimulla. Now, this judgment came out just before our Court of Appeal hearing in the Haycocks case. And in that case, there was a pool of one used despite other employees in the same or similar roles in other geographic locations. And the EAT held in that case that the tribunal must apply the litmus test of reasonableness to the process and decision-making of the employer. And it says, as set out above, this requires a tribunal to consider whether the employer genuinely applied their mind to the question of the pool from which employees should be selected, and to determine whether the pool selected came within the range of reasonable approaches open to a reasonable employer. So I've just been asked to repeat the case name. So that's Valimulla, Valimulla. And essentially in that case, the EAT held that the employer has to show that they've genuinely applied their mind to the question of the pool, and the tribunal has to consider whether the pool selected came within the range of reasonable approaches open to a reasonable employer. At paragraph 32, the EAT went on to say that consultation only appears to have taken place after what was the key decision had been made, namely the identification of the pool. And therefore, the consultation could not have been meaningful in respect of that key issue. So this case suggests that the employer ought to have consulted the employee on the pool, especially in a pool of one case. So employers need to be careful about those decisions, and they need to carefully consider whether they should consult around the pool of employees being used, and they need to consider whether other affected employees should be part of that pool or part of the consultation process before crystallising that particular decision. Now, another case that's worth mentioning, that the judgment was handed down in January 2024, is Hendy Group Limited and Kennedy. Now, in that case, the EAT agreed with the tribunal that the employer had done nothing in terms of alternative employment. The EAT held that the claimant was not told, the claimant was effectively treated as an external applicant. So the claimant was told that he could apply for jobs on the website. The HR communicated with him via an email to which he did not have access to. HR didn't tell managers that he was at risk of redundancy, so that wasn't a factor taken into account when he applied for roles. And there were no other there was no other evidence of other steps having been taken to assist the employee in finding a role, such as speaking to employees about what their interests were, what roles they might be suitable for, or identifying roles that would be appropriate for them. And there was no conversation around the different roles available. And it was found that reasonable employers would have been more involved in that search for suitable employment and having those discussions about alternative roles. And importantly, in that case, on the Polkey consideration, it was found that the respondent, if the respondent had carried out its responsibility in terms of considering alternative employment, then the claimant would have secured another role within the business. So there was no Polkey reduction. So this is a case which provides a word of warning to employees and practitioners advising on redundancy, because it suggests that simply sending at-risk employees the vacancy lists and asking them to apply for roles may not be sufficient. And we often see that in redundancy cases, that employers simply send out the vacancy lists with the at-risk letter, or during the consultation meetings, the vacancy lists are shown, but then it's left to the employee to identify the roles that they are interested in, with no real discussion around what is available and what might be suitable for them. So this particular case suggests that employers should be doing more in searching for alternative employment for at-risk employees. So I sidetracked there for a moment, but I think it's useful to see the lay of the land on redundancy and how the EAT are treating redundancy cases. Now, coming back to Haycocks, and this is another point which potentially shows the pendulum swing of how the EAT are treating these cases. The scoring of others in a matrix process and whether those scores are disclosable was an issue that reared its ugly head in Haycocks, albeit the point wasn't pursued and therefore wasn't fully considered by the EAT. But what was said about it suggests that the door may be ajar for developments in that area. So I mention it now as something to watch going forwards. Now, one would think that the British Aerospace and Green case makes it clear that the scoring of others in the pool does not need to be disclosed to people at risk or the claimant in tribunal proceedings, even if it's requested. However, the EAT seem to have other ideas in Haycocks. So on the SIFT, the EAT said it is also arguable that where such consultation has not taken place, so this is consultation at an earlier stage, or at a formative stage, a fair process would allow details of the scoring of employees in the pool to be more widely shared at a later part of consultation. As I say, that wasn't pursued at the EAT, but at paragraph 15 of the EAT judgment in Haycocks, the EAT seemed to leave the door open to some developments in that area, because it suggests that that might be arguable if an unfair or lack of consultation has taken place. So it would not surprise me if we see the EAT pushing further at that door in the future if the right case presents itself. So at the EAT hearing itself, the discussion primarily focused on consultation about the ways of avoiding redundancy, such as reduced pay or reduced hours. And that is what in turn led to the introduction of the concept of general workforce consultation in the EAT's judgment. So coming back to the slides now, on this slide, we've set out what the EAT essentially found. So it found that the statute is always the keystone to tribunal decision making. And as you'll be aware, there's a wide discretion under Section 98 of the Employment Rights Act for the tribunal as a tribunal of fact to determine reasonableness. And the EAT restated that at paragraph 21 of their judgment. Then at paragraph 22, the EAT summarised the key principles applicable to redundancy consultation. So there's a requirement to warn and consult. Consultation must take place at a formative stage where the employee can still influence the outcome. Adequate information and adequate time to respond needs to be given for a genuine consultation process to take place, and conscientious consideration given to the employees' responses and input. The purpose of consultation is to avoid dismissal or ameliorate the impact. The redundancy process must be viewed as a whole, and an appeal may correct an earlier failing. The tribunal should look at the whole process, not just any particular part of it. And it's a question of fact and degree as to whether consultation is adequate. So a failing in one aspect does not necessarily mean consultation overall is unfair. It must be looked at in the round. The use of a scoring system does not necessarily make a process automatically fair, but the relevance of individual scores will relate to the specific complaints raised in the case. So there we see the reference to British Aerospace and Green. So far, so good, save for potentially the point about British Aerospace and Green. But then the EAT went on at paragraphs 28 to 29 to introduce the concept of general workforce consultation in addition to individual consultation. So they said, we consider that the purpose of collective consultation is actually a reflection of good industrial relations in either type of workplace. So that's in those where there's a trade union and those where there's no trade union representation. And that such consultation should generally occur at the formative stages of a process. That might be better described as general workforce consultation rather than collective, which is a word that has connotations of union representation. The importance, however, is the purpose of consultation at that stage and not the label attached to it. And this is the key point. The individual stage of consultation is, as we indicate, more personally directed. This stage would generally consider such things as alternative employment. However, again, it is not for us to be prescriptive, but such consultation would usually be expected to occur in addition to the collective stage. And the EAT went on to find that that type of consultation had not happened in this case, and therefore the dismissal was unfair. And they set that out at paragraph 32, which I've put on the slide. Now, what's not clear from the EAT judgment, and you'd be forgiven for not realising that this took place in the case, but ADP had allowed for that type of discussion, albeit in individual consultation meetings, and those meetings having taken place with all 16 employees in a pool. So whilst there wasn't a separate group consultation or group discussion about the redundancy, discussions about ways of avoiding the redundancy had taken place in individual consultation meetings. So off we went to the Court of Appeal, and at slide 8, I've set out there what the grounds of appeal were in that case. Now, the discussion at the Court of Appeal really focused on consultation on the selection criteria and the stage at which the scoring took place. Now, the Court of Appeal was not happy with the fact that the scoring had been done before the selection criteria was sent to employees and before the consultation had commenced. And I was met with some surprise when I said that the scoring could simply be torn up and redone if consultation had led to comments or changes to the selection criteria. Nevertheless, the Court of Appeal ultimately agreed with us, and that is an appropriate point to hand over to Kieran to explain what the Court of Appeal's decision was and the practical tips arising from it.
Thanks, Charlene. So the Court of Appeal handed down its judgment in October last year, and as you may have gathered by now, they overturned the EAT's decision and they restored the tribunal's finding that the dismissal had been a fair one. And as far as what the Court of Appeal had to say about the general principles regarding this area of law, in many ways, the upshot of the decision was that the law is what it's always been, a sort of business as usual type of judgment. The Court of Appeal endorsed the summary of the principles that the EAT had set out in its judgment at paragraphs 21 and 22, and which Charlene just talked us through. You'll recall that the EAT had said that if the guidance from the case law didn't apply, or had been departed from in a particular case, then the ET would be expected to explain why not. And Lord Justice Underhill said that he broadly agreed with that, but that it shouldn't be treated as stating a rule of law. And I suppose in many ways that's a theme that runs through the Court of Appeal's decision, the idea that there are very few hard and fast rules that apply in this area. We say it so frequently that it almost becomes a truism, but there really is no substitute for the words of the statute. And all that the statute asks is whether the employer has acted reasonably or unreasonably in the circumstances. The Court of Appeal's judgment at paragraph 55 notes that actually the range of circumstances that might arise in small-scale redundancies in non-unionised workforces, just like this one, might be thought to be particularly wide. And that's almost certainly right in circumstances where rigid processes are not prescribed either by a collective agreement or by statute. And I suppose, in short, there are many ways to run a redundancy process that satisfies the relatively modest requirement to act within the band of reasonable responses. So turning then to what the Court of Appeal had to say about some of the specific and more unusual points that arose in this case. The first and perhaps the most important is how it dealt with this issue of general workforce consultation, which the EAT appears to have introduced as a requirement for fairness, even in small-scale redundancies like this one. The Court of Appeal agreed with the EAT that there is a danger in unthinkingly applying the label of individual and collective to particular forms of consultation during a redundancy process, and to pigeonholing certain issues as being either one or the other. Quite often the question of whether redundancies can be avoided altogether, or if some plan can be suggested to reduce the number of redundancies, might be regarded as a collective issue, which gets overlooked when consulting individually with employees. And the same can probably be said about the choice of selection criteria. But there's nothing stopping these things being discussed in the individual setting as well, particularly if the position is that there hasn't been a formal collective process taking place. And on the other hand, questions of suitable alternative employment are often regarded as individual consultation matters. And I think that probably makes sense to see that primarily as an individual issue, but you can imagine scenarios where that might not always be the case. For example, if a particular function of a role is being removed, but there's an argument that actually the group of employees carrying out that role could in fact do something else, you could see that that creates a situation where the issue straddles the individual and collective. I think the nub of the Court of Appeal's conclusion is captured in what I've put on the slide, which is that where there is no collective consultation, individual consultation should give employees the opportunity to express their views on any issue that may affect the risk of their dismissal or its consequences. In short, consultation on the range of issues, both the common issues and the individual issues, ought to happen in any fair redundancy process. Now, that in itself isn't controversial, but the really key question, and the point that I think had people scratching their heads about the EAT's decision in this case, is how that needed to happen. Because the EAT appeared to be saying that it had to be some sort of group or workforce level, and therefore happen in a fashion that looked similar to the statutory or the union collective consultation context. And as to that, the Court of Appeal disagreed with the EAT. It said that consultation on the common or group issues doesn't have to happen through a form of general workforce consultation, and there is no rebuttable presumption of unfairness where that doesn't happen. And Lord Justice Underhill gave two main reasons for reaching that conclusion. First of all, it seemed as if the EAT had been seeking to remove the dichotomy between redundancy situations where collective consultation was required, either with employee representatives under Tolreca or a trade union, and where it wasn't. But he said that those two situations were fundamentally different, because in the former scenario, there is someone specifically appointed to, and who can be treated as, expressing the view of the workforce. But at a general workforce consultation meeting, nobody would have that mandate. Employees would either express their views or they wouldn't. And I think practice shows us that very often employees don't express their views, or don't express views in a developed and detailed way in the context of those meetings. He did say that group meetings might be a useful way of ascertaining the views of employees, but their appropriateness would depend on the circumstances. And the second main reason that Lord Justice Underhill gave for rejecting the concept is that it just wasn't clear enough what was meant by general workforce consultation. And if an employer was going to be required to implement that in order to ensure the fairness of dismissals, there needed to be sufficient guidance either in the case law or in something like ACAS guidance, and the EAT hadn't provided that. The Court of Appeal went on at paragraph 55 to say, I can see no justification for creating a presumption which would depart from the repeated message of the authorities that redundancy situations arise in an extraordinarily wide variety of circumstances, and that the adequacy of consultation has to be considered on a case-by-case basis. So, general workforce consultation, well and truly put to bed as a requirement for a fair dismissal in this sort of redundancy situation. The next issue was the question of what consultation at a formative stage meant. And that expression came from the British Coal case in 1994 about what good consultation looks like, albeit not in the employment context. Now, as far as that issue was concerned, there wasn't actually much between the parties on it, and you can see the different ways in which it was put before the Court of Appeal on the slide. In effect, consultation at a formative stage means at a stage where it can make a difference to outcomes, or at a point when the employee can realistically still influence the decision. And I've underlined the important practical point here, which is that obviously the later in the process that consultation happens, the harder a time you're likely to have in showing that the decision hadn't already been made and the decision maker's mind was closed. But if you can evidence an open mind throughout the process, even quite late in the process, or even at the appeal stage, it might be said that the requirement of consultation at a formative stage has been satisfied. And I suspect that probably goes some way to answering Mark Long's question that I see in the chat, but we can come back to look at the questions that have been posed at the end. The next slide really goes on to just show how that played out on the facts of this case. As long as the die wasn't irrevocably cast, or as long as ADP would have been prepared to reconsider, regardless of how late in the process that was, regardless of how unrealistic that might have seemed in practice, that might be enough. Now, obviously, it will all come down to the evidence, including the documentation that was issued by the employer as part of the process. We'll come on to talk about that in a minute, whether that is the case or not, and whether the employer is capable of demonstrating that. So just taking a step back and looking at where the Court of Appeal decision leaves us, I think there are a few headline points that emerge. The first is that the statute remains the key. Comper maxim is still the leading case, objective selection criteria fairly applied, warning and consultation, consideration of suitable alternative employment. We focused on consultation here, but these three things will all continue to be the main battlegrounds in redundancy ordinary unfair dismissal claims. Secondly, there is no requirement for general workforce consultation, but generally speaking, the common or group issues should still be consulted on, even if that happens during the individual consultation meetings. Open-mindedness of decision makers and being able to evidence that open-mindedness might well save the fairness of redundancy consultations that begin when plans are already in an advanced stage, or where the scoring has taken place before the redundancy process begins. And as with all unfair dismissals, do not underestimate the value of a thorough appeal in being able to remedy unfairness earlier in the process. And that's our trusty old Taylor and OCS coming to the rescue. In the context of this case, as Charlene's already mentioned, the careful consideration that was given to the scoring during the appeal was one of the things that saved ADP from an area where it had clearly departed from good practice. The timing of the scoring exercise and failing to provide the scores in advance of the dismissal. So thinking of some practical tips, there are a few lessons that emerge from the case itself and tips that we can take away, I think. The first is, ideally don't carry out the scoring before the consultation process begins. It might not necessarily render the dismissal unfair, but it's not a great start when you're trying to convince the tribunal that you ran a fair process. Secondly, make sure that employees receive their scores and have an opportunity to comment on them before their dismissal. It remains the case that it won't generally be required to provide other employees' scores, But again, it depends on the circumstances, and as Charlene noted, it's an area where there is potential for development in the case law. And thirdly, as far as selection criteria go, some level of objectivity is helpful. In Haycocks, there were 17 criteria, and most of them were fairly subjective. Although there had been no challenge to the decision maker's good faith, it would undoubtedly have been better to have some more objective scoring criteria in there. Things like rates of absence, performance reviews, especially if that's informed by the feedback of more than one person, and things like that. That said, objectivity shouldn't be prized above all else. And Mr. Justice Underhill in Mental Health Care UK Ltd and Biluan 2013 case warned that a blind faith in an HR-driven process ran the risk of losing touch with common sense and fairness. So as ever, there is a balance to be struck. And a final observation in relation to scoring criteria is that employers, as ever, should be wary of potentially discriminatory criteria like length of service and absence-related criteria where absences might be due to disability. This case was just a straight ordinary unfair dismissal, so no Equality Act considerations there. But when advising on these things, we should always have an eye on the potential for Equality Act claims to be brought. Now, from a big pictures perspective, excuse me, there are several other practical tips that I'd suggest. Now, the obvious caveat here is that we all know that our clients are operating under commercial and management time constraints. It's not always possible to run a flawless process, and sometimes clients will want to cut corners. We know that fairness will always depend on the circumstances, but I'd suggest that there are things which are more likely to point towards a fairer process, which can relatively easily be put in place. The first point is around information. Give the employees enough information to be able to meaningfully engage with the consultation process. Even if you only end up having a couple of short meetings with them, you're then in a position to be able to say, well, they had all of this from the outset and were able to challenge it. Secondly, actually consult. This is the time-consuming bit, but unfortunately, it's a necessity. Ask them if they're able to suggest any alternatives. You can even explicitly ask if they feel that they've had sufficient opportunity to comment on things like their scores, because evidence of them agreeing to that is likely to be useful in a tribunal down the line, although I appreciate it runs the risk of opening a can of worms if they say no, but it's useful for you to take on board what they're saying and to be able to engage with any suggestions that are made. Part of actually consulting is also making clear that consultation is an ongoing process, and it's ongoing throughout the consultation period. Provide an HR or management contact. Make sure someone is actually responding to questions or providing further information that's requested. It will always look bad if queries have been raised and gone unanswered. And similarly, if someone says during a consultation meeting with an employee that they'll get back to them on something, make sure that they actually do. Thirdly, consultation isn't just for the people at the bottom of the pool. It should take place with everyone who is at risk. And finally on this slide, remember the collective issues. You shouldn't assume that they don't have anything, I say the employees, don't have anything to suggest on how to avoid redundancies, for example. It might be in practice unlikely that they don't, but asking the question will make for a fairer process overall. Continuing with the practical tips in the final substantive slide, you want to be able to evidence a fair process. This is a really important one. The contemporaneous evidence is really important by the time you get to the tribunal, and you can get ahead of the curve and put yourself in a strong position by doing things like using template meeting scripts and ensuring the things that I've set out before are covered in those scripts. Follow up with letters reiterating what has been discussed in writing. Keep notes of the meetings that take place. And that ties into the next point about open-mindedness. Once the scoring exercise has been done, it may be that, practically speaking, there isn't a lot an employee can do to change the position. But even so, decision makers should be encouraged to keep an open mind, and the paperwork should underscore the position that no decisions have been taken and that any suggestions by employees will be taken on board. And if the paperwork reflects that being the position, it's more likely that it will reflect what actually happens in practice and the approach that decision makers take. Finally, training managers before expecting them to carry out what's a fundamentally complex process that has the potential to be a legal minefield might well be an investment worth making if the result is not having to deal with unfair dismissal claims. No doubt there are a million and one other practical tips that could be suggested. Those are just some of the ones that have come to my mind emerging from this case. I know that a lot of the solicitors we have on this call will have spent endless hours dealing with various aspects of redundancy consultation processes. So by all means, feel free to weigh in and let us know what you think. But that is everything from me from a substantive perspective.